The American government and the American way of living are based squarely on the Constitution. Under this remarkable document, America became a democratic republic. That is, democratic meaning the control of the government is in the hands of the people, and republic meaning that the people elect men and women from among themselves to represent them in running the affairs of the nation. Obviously, each and every citizen could not be available to discuss and vote upon each article of business. But each citizen has the right to vote and run for public office to represent his fellow citizens. Now, we are going to take a close look at the Constitution that Washington, Franklin, Hamilton, Madison, and the other great American leaders gave us. Our Constitution begins with an introduction called the Preamble. The first words are, "We, the people of the United States." Our government's decisions are based on the desires of the majority of the people. At the same time, it protects the rights of each individual and of minority groups. The basic principles set forth in the Constitution are 1. A republican form of government. 2. Equality of citizens before the law. 3. Protection of personal liberty and of property rights. 4. Separation of church and state. 5. Separation of powers among the departments of the federal government. 6. Federalism, or the division of the powers of government between the nation and the states. 7. Popular sovereignty. 8. Supremacy of the Constitution and of all federal laws and treaties made under it. And 9. The right of the people to amend the Constitution. The Preamble lists the reasons for setting up the Constitution. It reads, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States." To form a more perfect union means organizing a better plan of government than that under the Articles of Confederation. As we have seen, there was no real union under the Articles. Each state went its own way, quarreling with its surrounding neighbors and taking upon itself authority and responsibilities it could not properly handle. But under the new Constitution, the states remained sovereign, with an equitable division of powers between themselves and the federal government. The powers not delegated to the United States by the Constitution are reserved to the states or to the people. The national government has its powers from the states. The states retain residual powers to themselves, such as regulating education, marriage, divorce, automobile traffic, and many other important aspects of everyday life. Powers which are exercised by both the states and the national government are called concurrent powers, such as taxation. Establish justice means setting up a system of government under which all citizens would be treated fairly. Each man, and after 1920, each woman, who was either born or naturalized a citizen of this country, was entitled to make his voice heard in the affairs of the country. He had a vote. He was entitled to take a direct part in the government. He could run for elective office. Later on, in the Bill of Rights, the constitutional concepts of justice were enumerated. The Constitution states, "Establish justice." But many people would not agree to ratify it under such general terms until they were assured that the exact applications of justice would be specifically set down as part of the document. Americans who had suffered much injustice under the English knew quite well what they didn't want as well as what they did. Insure domestic tranquility means seeing that there is peace inside our country. This turned out to be a big job, for over the years, government troops have had to be called out often, and for a variety of reasons, from putting down Indian uprisings, quelling riots, establishing order during labor strikes, and recently, making sure that the states did not interfere with the civil rights of individual citizens. A nation at peace within itself is a strong and secure nation. It is the responsibility of the government to maintain that strength and security by every available means. There is an old saying, much used by would-be world rulers, divide and conquer. A people living and working together in tranquility cannot easily be divided and are very hard to conquer. Provide for the common defense means that the government would set up a strong army and navy to defend our country. Later, of course, other branches of the armed forces were added, the Air Force, the Marines, the Coast Guard, etc. Although he may not have the direct power to declare war, our President, as Commander-in-Chief, may send our armed forces outside our boundaries to protect individual citizens or their property, to enforce national policy, as in the Vietnam situation, to fulfill international treaty obligations, for example, the American soldiers stationed in Berlin, and to guard the nation's safety. Promote the general welfare means doing everything possible to make this country a better place in which to live. This broad general precept involves every area of American life, from education to medical care, to the national living standards, business and labor relations, public utilities, employment opportunities, crime prevention, law and order, and much more. It involves every department of the national government and a constant search for new ways of improving the lot of the American citizen. Secure the blessings of liberty to ourselves and our posterity means to provide liberty for us and for those who come after us. By making the Constitution so detailed, and by carefully providing for the rights of each individual and all minority groups, the authors assured all Americans, past, present, and future, of a sound, flexible, just, secure, and equitable governmental structure. The Constitution set up a federal government divided into three branches: the executive, the legislative, and the judicial. Each of these government branches has great powers which are derived from the people. Our most important officials serve for stated terms and, unless re-elected, return to the ranks of the citizens. Ours is a government of laws rather than men. Officials are not masters of the state, but public servants. The legislative branch was to make laws. All new laws are first considered as to whether they are constitutional or not. Before any proposal becomes a law of the land, it is called a bill. Bills are introduced to the legislature by various committees and then discussed, revised, and finally voted upon by the members. A bill passed by 2/3 of both houses of the legislature becomes law if signed by the chief executive, or passed over his veto, or automatically become law if after 10 days he neither signs nor vetoes it. The executive branch was to carry out or enforce the laws. The chief executive may have the advice and help of the principal officers in each of the executive departments. He, however, does not have to follow their suggestions. He may veto bills, call Congress into special session, and recommend legislation. Because, as chief executive, he is the head of his party and controls appointments to many federal offices, he may exert great personal influence with members of Congress. He may also, as head of the government, appeal to the nation through the radio, press, and television when Congress does not do what he wishes. The judicial branch was to decide whether or not the laws agreed with the Constitution. The courts settle disputes arising under the law, judge violations, and punish offenders. In the United States, two separate judicial systems exist side by side. One, the state courts, which hear cases under the constitutions and laws of the states, and 2. Federal courts, which consider cases arising under the Constitution of the United States, treaties with foreign nations, and laws of Congress. The judicial branch is the balance of our system of government. It helps maintain the proper constitutional relations between the executive and legislative branches, and also between the states and the central government. The Constitution provided for a Congress of 2 houses, the Senate and the House of Representatives. This is called a bicameral body. It was designed as a check on hasty laws and as a concession to the small states. All members of the Congress, upper and lower houses, are paid by the federal government, not by the states. The upper house, or Senate, is made up of 2 representatives from each state, elected by popular vote for a term of 6 years. The Vice President presides over the Senate, but has no vote unless there is a tie. The lower house, or House of Representatives, is made up of representatives chosen by popular vote for a term of 2 years. The number of representatives for each state is based on the population of that state. The presiding officer of the House is the Speaker, a regularly elected representative. Congress has the power to tax, borrow money, coin and print money, declare war, punish treason, regulate foreign and interstate commerce, issue patents and copyrights, maintain post offices, create lower federal courts, and to propose amendments to the Constitution. In addition, there is an elastic clause which gives Congress the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by the Constitution in the government of the United States. The Constitution set up the position of the President of the United States. It provides for a chief executive who is elected for a term of 4 years by the presidential electors of the various states, each state casting as many electoral votes as the total number of its seats in both houses of Congress. The President may not be removed from office except upon impeachment charges brought by the House and sustained by 2/3 of the Senate. If he dies in office, he is succeeded by the Vice President. The President of the United States, by virtue of the authority, prestige, and power he possesses under the Constitution, is the most important elected official in the world today. He issues executive orders needed to carry out laws. He appoints department heads, federal judges, ambassadors, and other officials. He negotiates treaties. He is commander-in-chief of all armed forces. He can veto congressional bills, call extra sessions of both houses, grant reprieves and pardons, and recommend legislation. The Constitution gave the President the power to enforce laws passed by Congress. He issues executive ordinances needed to carry out the laws. In time of war or economic depression or other national emergency, Congress usually has granted the President wider authority, backed up by the Judicial Branch. The Constitution set up a Supreme Court and gave Congress permission to set up lesser courts. The Supreme Court, which is the highest tribunal in the land, is composed of the Chief Justice and 8 associate justices. Its size, which is fixed by Congress, not the Constitution, was changed many times in our early history, but not since 1869. Lawsuits affecting ambassadors, other public ministers, consuls, and states are brought to the court directly. This is its original jurisdiction. All other cases, the Supreme Court hears on appeals, which may come from lower federal courts or state courts. The decisions of the court, which are by majority vote, cannot be appealed to any other court. The Chief Justice presides over the Supreme Court, but his vote is counted the same as any associate justice. To assist the Supreme Court, Congress created 2 sets of lower courts, the United States District Courts, which serve as the lowest federal courts, and the United States Circuit Court of Appeals, which hears appeals from the district courts and from the rulings of executive agencies. Congress has also established various special courts, such as the Court of Claims and the Customs Court. Federal judges hold office for life or until they retire, and may not be removed except through impeachment. A system of checks and balances was set up to check the power of one branch by the power of another. The President may propose legislation, but he cannot make laws all by himself. The President's appointments must be approved by a majority of the Senate. Treaties must pass the Senate by 2/3 vote. Though the President is Commander-in-Chief of the Armed Forces, the power to declare war resides solely with Congress. A bill passed by both houses of Congress may be vetoed by the President, but his veto may be overridden by a 2/3 vote of each house. A law may be set aside by the courts as unconstitutional, but Congress may then ask the states to approve a constitutional amendment. The Constitution provided for admission of new states and so made possible the growth of a large nation. Under this wise provision, the Union had expanded from 13 to 50 states, all on terms of complete equality with the first members. A new state may be formed out of the territory of an existing state only with the consent of the legislature of that state. The authors of the Constitution wrote in a plan for amendments or changes. The proposed amendment must be approved by a 2/3 vote of both houses of Congress, or by a convention called by 2/3 of the state legislatures. Then it must be ratified or accepted by legislatures in 3/4 of the states, or by conventions in 3/4 of the states. Since 1789, only 22 amendments to the Constitution have been adopted. The first 10 amendments are known as the Bill of Rights. These amendments were written into the Constitution and adopted all at one time. The other amendments have been added separately and slowly. Some of the most important are the 12th, which provided for separate ballots for electing the President and the Vice President, the 13th, which prohibited slavery, the 14th, which defined an American citizen as anyone born or naturalized in this country, the 15th, which forbade the national government or any state to deny the right to vote to any citizen because of race, color, or previous condition of servitude, the 16th, which began the income tax, and the 19th, which gave women the right to vote. Freedom of religion, of speech, and of the press are some of the rights guaranteed by the first 10 amendments. The government was forbidden to establish or support any official state church. The states are allowed to maintain armed troops or militia. Members of the armed forces cannot be lodged in private homes without the consent of the owners. Federal officers may not search private property or arrest persons without specific warrants issued on the basis of adequate evidence. Arrested persons have the right to public trial by an impartial jury, to bring witnesses to testify on their behalf, to have legal counsel. Excessive bail must not be required, nor cruel and unusual punishments inflicted. This last refers to some of the terrible methods of torture and execution in common use throughout Europe in those times, such as prisoners being hung, drawn, and quartered, boiled in oil, branded, mutilated, and maimed. After listing all of these specific rights of Americans, the Bill of Rights goes on to say that just because certain rights are enumerated in the Constitution, it does not mean that the people may not possess other rights which are not enumerated. This is a diagram of the elective process of our government. The people of the United States elect the members of the Electoral College, which elects the President, who enforces the laws, appoints cabinet members, judges of the Supreme Court, and other federal courts. The courts interpret the laws. The people of the United States also elect the members of both houses of Congress, which makes the laws. Now, let's see how well you remember. Here is a list of 6 statements, one of which is false. See if you can spot the false one. 1. The reasons for the Constitution are stated by the Preamble. 2. A system of checks and balances was set up by the Constitution. 3. A plan of amending the Constitution was provided. 4. The first 10 amendments are known as the Bill of Rights. 5. The Constitution provided for a president, 2 houses in Congress, and a Supreme Court. 6. The President, as Commander-in-Chief of the Armed Forces, may declare war if the nation is attacked. Did you spot the false statement? Here are the true ones. Things to remember. 1. The reasons for the Constitution are stated in the Preamble. 2. A system of checks and balances was set up by the Constitution. 3. A plan of amending the Constitution was provided. 4. The first 10 amendments are known as the Bill of Rights. 5. The Constitution provided for a president, 2 houses in Congress, and a Supreme Court. Number 6 in the first list was false. The President, as Commander-in-Chief of the Armed Forces, may declare war if the nation is attacked, is wrong. Under all circumstances, only Congress may declare war is correct. In adopting the new Constitution, America had taken a great beginning step into the future. Without it, she was going around in circles, headless, powerless, and prey to the first strong foreign power which cared to step in. But the Constitution gave the nation a head and 3 strong arms, the executive, legislative, and judicial branches of government. Now it remained for the world to see what kind of a government a democratic republic would turn out to be.